All right, and Mr. McLeod, good morning, sir.
Morning.
We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess.
Okay.
So I'd like to open.
Welcome back to another courtroom roller coaster. Today we're heading to Michigan, where a self-proclaimed sovereign citizen takes his delusion straight into a probable cause hearing, and spoiler alert, it doesn't end well. The man you're about to meet isn't just fighting the system, he's fighting logic itself. From motions to suppress imaginary evidence, to demands about jurisdiction. This guy brings a masterclass in how not to represent yourself. Stick around, because as the judge dismantles each of his claims, we'll break down exactly how the law really works versus what the defendant thinks it does. Get ready, this one's part legal lesson, part comedy show, and 100% courtroom chaos.
Initially on that day, we were doing a BUI patrol. Other COs notified that there was a boat with expired registration. Subsequently, we found out that the defendant was intoxicated while he was operating the vessel. And that led to the arrest of him. Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He stumbled and swayed back and forth along the dock and up the ramp of the boat ramp. While talking to him, I observed slurred speech. I noticed that it took him about 10 seconds just to put on one of his sandals. Myself and Officer Listenfeltz, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused. Officer Listenfeltz got inside of the vessel with him. The defendant pulled away from Officer Listenfeltz. A scuffle erupted. He put his arms in front of him so that way he couldn't be cuffed. Time I pulled out my taser, I took the cartridge off so that I could use the dry stun option. And then finally, Officer Listenfeltz was able to pull his right arm.
Here's where the sovereign citizen logic starts to shine through. The defendant's upset that he just received a warrant magically on Friday, claiming it proves corruption or misconduct. But in reality, this is just how case discovery sometimes unfolds. Paperwork gets logged and shared through proper legal channels. The problem isn't the timing, it's that he believes procedural delay equals conspiracy. It's a common sovereign citizen tactic. Focus on paperwork instead of facts. The judge, though, has heard this all before. What's coming next? A reality check wrapped in legal precision.
To suppress the chemical test results, Mr. McLeod?
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in Discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you. Mr. Juliet?
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test. When offered one, based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, That blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore it didn't violate the Fourth Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. That doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit at the jail for him. Whether that got to him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the Fourth Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied.
Let's pause for a second. The officer's testimony was straightforward. Probable cause, intoxication signs, refusal to comply, and even a scuffle. But here's the key takeaway. Boating under the influence is treated just like driving under the influence in most states. You can't escape responsibility by floating on a technicality. Yet our defendant seems to think that if he questions how the paperwork was stapled, he can overturn the entire case. Spoiler, the law doesn't care about your filing preferences when you're slurring through sobriety tests.
You also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet.
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Visnot. So I don't think there could be any prejudice by failing to hold a probable cause conference.
All right, yeah, Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
probable cause conference is going to stop a lot of this procedures because the probable cause is all.
This moment is pure courtroom poetry. The judge just delivered a textbook Fourth Amendment explanation, calm, factual, airtight. The defendant tried to argue that the warrant was invalid or improperly served, but the judge dismantles it in seconds. Why? Because the existence of a valid, judge-signed warrant completely neutralizes his argument. The law isn't based on feelings of unfairness. It's based on legal process and evidence. And right now the evidence says, you were drunk on a boat and the cops followed procedure.
Probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to it. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
You say exercise my right to preliminary. Wasn't that kind of a forced situation under duress and threat?
This is where things get hilariously messy. The defendant's arguing about a probable cause conference, a procedural meeting meant to check scheduling and plea issues, and he's treating it like the trial of the century. What's happening here is the classic sovereign citizen confusion between procedure and substance. He's mixing up the paperwork for the process itself. But the judge keeps his composure, patiently explaining how the system works. Honestly, at this point, the judge deserves an award for judicial endurance. The man's explaining Civics 101 in real time.
So you exercised a right and it was held. So there's no harm to you. You exercised a right. All right. Now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police.
This part might be my favorite. The defendant literally files a motion to reconsider a denied motion to reconsider a denied motion. That's not a tongue twister. That's exactly what he did. It's like watching someone hit undo 3 times, hoping the computer suddenly agrees. The judge's tone stays calm, but you can hear the disbelief in his words. And when the defendant admits he doesn't even understand his own motions, that's when you realize self-representation can be the fastest route to self-destruction.
There's the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed 3 more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore either. I need more time to file these motions.
Nope. No, today's the motion cutoff. You filed 3 more. I'm going to hear them today. You have a motion to dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did. This motion,
you have your own jurisdiction.
this motion is denied. This court does indeed have subject matter jurisdiction over the charges by law
Personal or subject
and personal
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about.
I don't know. Somebody else handled it.
Now we're deep in sovereign citizen bingo. The defendant's ranting about jurisdiction and bond disclosure, classic buzzwords from online pseudo-legal communities. These arguments are recycled nonsense, based on the idea that courts only have authority if you consent. But here's the truth: jurisdiction isn't optional. If you break the law in Michigan, you're under Michigan's jurisdiction, period. The judge's patience here is incredible, calmly denying motion after motion, even when the defendant accuses him of bias. At this point, it's not just a hearing, it's a one-man seminar on how not to use Google as your lawyer.
And Mr. McLeod, I'm letting you represent yourself, and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
That motion is denied. It again is legal nonsense.
Questions that you're answering and having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and you keep claiming that you do. It's clearly written in the consent decree that you don't.
It's manifestly untrue, Mr. McLeod. The consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You have an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that
So I
I'm wrong.
want you to stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not on.
And there it is, another sovereign citizen fantasy crushed by cold, hard law. The judge methodically denied every motion with professionalism and clarity, proving once again that courtroom theatrics don't trump legal facts. What stands out here is how these defendants often mistake confidence for competence. But the justice system runs on evidence, not ego. The takeaway? Always know your rights but also know your limits. Self-representation without understanding the law is like showing up to a chess match without knowing how the pieces move.